How to respond to an cease and desist letter. Have you ever received a letter claiming you are infringing on someone's intellectual property? If so, you may be wondering how to respond to an intellectual property cease and desist letter. This situation can be stressful, but knowing how to handle it can make a big difference. Let's break down the steps you should take to respond effectively. First, take a moment to read the letter carefully. It is essential to understand the specific claims being made against you. The letter will outline the intellectual property rights asserted, whether they are related to trademarks or patents. It will also detail the activities that the sender believes are infringing and what they demand you to stop or do. Pay attention to any deadlines mentioned for your response. Next, assess the validity of the claims made in the letter. If the letter concerns a trademark, check the registration status and the first use dates of the trademark. For patents, verify the patent number and claims to see if your product or process falls within the patent scope. This may require some technical or legal expertise, so don't hesitate to seek help if needed. Consulting an intellectual property attorney is a smart move. They can help you evaluate the strength of the claim and advise you on your rights. An attorney will also guide you in crafting your response strategy, which is crucial in these situations. Now you need to decide how to respond. You have several options. Ignoring the letter is risky, as it could lead to legal consequences if infringement is proven. Alternatively, you can respond to the letter by denying the infringement, requesting more evidence, or clarifying your position. A well-crafted response can prevent the issue from escalating. Another option is to negotiate a settlement. This could involve reaching an agreement that allows for limited use of the intellectual property or licensing terms that benefit both parties. If you believe you do not infringe or have valid defenses, you may also consider preparing for litigation. In this case, seeking a declaratory judgment from a court could resolve the dispute. When crafting your response, keep it clear and professional. Address the claims factually and respectfully. If you deny the infringement, explain your reasoning with supporting evidence. If you plan to comply or negotiate, state that clearly. Avoid making any admissions of guilt or statements that could be used against you later. It is also important to keep records of all correspondence and documentation related to the dispute. This information may be vital if the matter escalates to litigation. Lastly, ensure you respond within any deadlines specified in the letter to avoid negative legal consequences. Remember, a cease and desist letter serves as a warning rather than a final judgment. Responding promptly and thoughtfully can protect your rights and may help you avoid costly lawsuits. Understanding the claims and engaging experienced legal counsel early on will help you navigate the resolution of intellectual property conflicts effectively.